Hi, it's Sean Lahman and Gary Craig, reporters with the Democrat and Chronicle, and we're here today with three members of the jury for the Craig Rideout murder trial. Let me start by asking you about that experience. The trial lasted several weeks, jury selection and then through the trial. Can you tell me a little bit about what that experience was like?
It was a long 3, 4, 5 weeks. 5 weeks. Was it 5 weeks?
It was
about 5 weeks.
Yeah, it was long, but it was a very interesting experience, and the jury members, we all got along, so
we spent a lot of time together,
yes.
and got to know each other, and found a lot about each other, a lot of things in common, a lot of things different.
Yes. And for me, as a history teacher, teaching a government teacher in the high schools, it was a fascinating process to watch the judicial system at work and everything. So I have never really been in a courtroom per se, and learned an awful lot about the process itself. A lot of information we learned, and we were basically inundated on a daily basis with all kinds of technical information, DNA, blood samples.
I learned a lot. I learned a lot about
spatter
that.
Spatter
versus splatter, and all that. So it was long though, and I think the judge in this case, Judge Moran, was very cognizant of how we were in the jury box and everything. He would ask us once in a while, have you had enough today? Or have you had enough right now? Do we need a break or something?
Yes.
So
Yeah,
he was very accommodating to us, and he was wonderful. In fact, all the lawyers were, because they had to approve that as well. So, but it was long, Sean. It was long.
I'm speaking with Claire Washington, Rich Bott, and Mary McKean, three of the jurors in this Rideout trial. You talk about the volume of evidence. I think there were close to 50 witnesses who testified,
54.
Maybe 700 or more pieces of evidence. How did you, once the trial was done and you guys went back to that jury room, how did you start the process of making sense of all of that?
Oh, I can speak to
Yes,
that.
Mary. She's our organizer.
Yes.
First of all, we just wanted to make sure that the evidence was separated so that there was a lot of things that ran together. So I asked if we could get poster boards. So for each different defendant, we could separate those out because they were actually being tried separately. So we didn't want anything running together. So we had to go through a lot of pictures, a lot of evidence, and on each wall separate them out so that we could actually look at them and deliberate with the evidence that we were given for that specific person.
So there were 4 defendants in this case, I think a total of 11 charges,
That's right.
Each of them with the second-degree murder charge, tampering charges, and Laura Rideout also had a burglary charge.
Right.
When it came to making a decision on each of those counts, I imagine that some of those decisions maybe were a little easier than others?
They were all pretty tough.
Yeah. There was no easy decision. And once we got going to it, that's why you saw it. I think you and I were talking about this. That's why you saw so many readbacks and everything.
Yes.
First of all, because of the length. I mean, you start with Mr. Weaver, the very first witness, and we finished with Mr. Kish, right, the last witness.
Right, yes.
And it was hard to remember all the details from the very first. That was 5 or 6 weeks before that. So
And the definitions.
the definitions and
for clarity.
I've got to be honest with you. We were a little stunned when we asked a particular word, and they couldn't tell us. They couldn't tell. If they couldn't tell us, we didn't know.
Yeah,
we were like, okay, so what does it? And we couldn't Google it or anything. We couldn't do that.
Couldn't look anything
We
up.
couldn't look anything up.
Yep.
So we had to ask again, and they finally did come back with something. And
Yeah,
told
it
us
took them a bit to find it.
It took
too,
them.
didn't it?
I think it was either the Oxford Law.
It was
Dictionary
actually a
or something.
definition from an appellate case, and that
Yes,
was...
1999 case, is it the one they're talking
I
about?
think so,
Yeah,
yes.
it actually was even a Rochester-based case.
Yes,
actually.
right.
Oh,
right.
wow.
Yes.
So, but they did get it for us, and but I mean, it was just so much information. It was at times it was almost information overload, and there was 54 witnesses, 680 pieces of evidence, and the DNA.
Learned a lot about chain of custody and DNA.
DNA transfer, and quadrillion and sextillions, all these different
Yeah.
numbers that we had never heard before.
Yes.
So, so we had to do the readbacks and everything because we just couldn't remember everything. And we had a strategy where, you know, we would have certain ones of us key in on certain parts of the definition. We'd go scramble back in and kind of write it down and talk
we had
about
to
it.
go back and forth. Clara and I always joke about the evidence in totality.
Yes.
That's
Totality.
when
Yes.
because, you know, you can take a specific piece of evidence, but when we were deliberating, you have to make sure that you take all the evidence and the sum and totality. And then make a final decision.
Yes.
You know, I learned a lot about beyond reasonable doubt.
Yes.
And that was hard to
Back
get.
up I'm sorry.
No, I was going to say that was hard to get beyond reasonable doubt because, you know, you have this perception, and then but when you get talking with everybody, it's like, well, okay, maybe, you know, it may not be what.
And what's the difference between impossibility versus reasonable doubt?
So
I mean,
words meant
we really
something
had
to
Yes.
us.
Yes.
Words meant something to us, and we focused on the words.
Back up when you talk about when you go in, you decide we're going to separate by the defendants. Did you then proceed like one defendant at a time with all of the charges per defendant, just by necessity did you have to sort of start bouncing around
Yeah.
occasionally?
We went back and forth
Yeah.
on some.
Yes.
But we only discussed one defendant at a time.
Yes.
So even though we might not have made a full decision on one, we went to another one and then went back because we needed a readback. And the readbacks, by the way, always took about like an hour or something, an hour and a
yes.
half for us to get that. So
God bless that woman.
yeah, oh, Deputy
very
Waters
patient, very thorough.
and Deputy Pete, they were wonderful.
Yes.
They were great. So
Were there any when you stepped into the room where you said, okay, we feel certain about charge A against defendant A right away, or was it?
No.
Yeah.
There was never.
Not immediately.
No.
Not
There
immediately.
was
Not at all.
never like this is it. Everybody agrees. You know, we had to go back and forth and really dig down in the evidence. And the other thing, you know, that we also, I mean, the younger people that were also in the jurors were fantastic because they were just exceptional in their breaking down of information and being so complete and going through everything. I mean, even they were thinking of things, but you have to separate what you think or believe because it's only according to the evidence.
Yes.
So
in the end, you convicted 2 of the defendants, Laura and Colin Rideout, of murder. You acquitted the other 2 of murder. You feel comfortable with that decision?
based on the
With some
evidence.
time.
yes, absolutely, absolutely.
Yes.
I have no reservations about it. And there was 12 of us. It wasn't just one person that wanted to convict versus not convict and everything.
Yeah.
So it was 12 of us, and we just didn't feel that the evidence was there, enough evidence to prove beyond a reasonable doubt for all of us. And no one, and I think we've talked about this before, no one was pressured at any point during the deliberations to change their mind.
Yes.
No one.
No.
Everyone, we said it'll take as long as it takes to get this done and get it done correctly. Make the right verdicts and everything, so.
And as far as like comprehension for spatter, not splatter,
Yes.
for spatter and transfer, I mean, we really had to break that down, really break
Yeah.
it down when you're looking at the evidence, you know, and that was very helpful.
Yeah.
And, you know, just as far as, you know, locations and maps and everything, I mean, we had to correlate everything. And if somebody didn't feel comfortable in the jurors, you know, I had some questions, you had some questions, you had some
Yeah, we all had
questions.
questions,
We would
yeah.
go back to that evidence and break it down so that everybody could understand what we needed to understand to come to whatever conclusion we were going to come to.
Yes.
So in addition to having some of the law read back and testimony read back, you did ask to look at some pieces of evidence, and some of those pieces I think you looked at more than once.
Yeah.
Yes.
Yeah.
How important was that, getting that opportunity to see those pieces? I know at one point one of the items was a pair of sweatpants. I saw some of the jurors get out of the box and look pretty closely at that.
Yeah.
How important was it to look at those pieces of physical evidence for yourself?
Well, like what Mary said with perception, that's why we had to see it a couple times, because some of us perceived the sweatpants different than others. So we had to look back and be like,
Right.
okay, how much blood? It wasn't that much. We thought it was a lot more. Oh, we needed to see how much blood was on those sweatpants to make our decision that we made.
And also, when we had to play back the testimony from the coroner, that was very important. And there was so much information in that coroner's report. We had to continue to play that back and get a part of it, process that part, and then move on to the next one. And some people still had questions.
Right.
That's fine. We'll just go right back to square one
Yep.
so that everybody can understand.
Yes.
And
I mean, we literally talked everything out. We focused on all 54 witnesses, and we also, I can't say that we dissected all 680 pieces of evidence, but we touched upon most of it.
Yes.
And we determined, like the judge told us, we determined how much weight to attribute to it. So,
exactly.
and and then like Mary has said, we looked at the total picture, not just one snippet from here and say, okay, one snippet. There was no smoking gun anywhere in there for us, so we had to put everything together.
Well, just returning to what you said though, Mary, as you said, all the evidence was vital, but what made the coroner's testimony particularly important as you guys were sort of winding down to getting close to your decision there?
How much of that can we talk about?
Well, I guess just,
I'm just-
I guess we really wanted to get a good idea of the cause of death and everything.
Yes.
And I know they talked about the strangulation with the garrote, as well as the possibly being hit with some blunt instrument, which we never knew exactly. No one ever came. I guess maybe in the closing arguments they summarized that it could have been an iron.
And the blood. The blood was very important in that coroner's, like
Yeah.
Clara said before. That blood, we had to follow it from start to finish.
Right.
And the finish really had, the coroner really gave us a lot of information, and as far as the evidence with the tarp, what was in the tarp, all of that is so specific, and each part of that we had to tear down, and for each person separately. So it took a lot of time and
did.
a lot of deliberation.
Yes.
So none of the defendants testified at this trial. And you did not hear from them. The only chance you really got to see them, other than sitting at the defense tables, were those 3 surveillance videos from Walmart. Can you tell me how important those were?
That was a tough one.
Yeah.
That was a tough one because of all the circumstances around that.
So the
they
video
were
showed
moving-
Laura and Colin Rideout, Laura and Paul Tucci, and then Colin Rideout shopping at Walmart in the days and hours before the murder allegedly took place. What did you make of what those videos showed?
There's a lot of pieces there as far as intent, right, Rich? I mean, you have to have intent. What was the purpose of those? What could be the purpose of them purchasing these
And what's
things?
logical, what's as far
Yes.
as like Tucci, he could have been going in, talking typical, going in with his wife or girlfriend or whatever is perceived on the video, and going in and shopping. And like they all could have been, but there's certain things were connected to the scene of the crime and to Yates County.
And you have to look at the logistics.
Yeah.
Yes,
I-
in the time.
I guess, Sean, out of the 3 videos, I mean, and I'm not going to be being specific and everything about which video, but I think there was certain videos that we weighted heavier than others that really kind of convinced us one way or the other on that. But I don't want to get into the specific ones on that and everything, so.
Thank you, Rich.
Yeah, okay.
Thank you.
Well, I will ask you one thing, and you may not want to get into this, but I know there's been some public discussion of the case by people who were not involved in this, who've been critical of some of the decisions that you made, particularly the decision to acquit Paul Tucci. So let me just ask you this. You feel comfortable now that, given the evidence you had, you made the right decision? with regards to Paul Tucci?
See, the thing about it is you can't go by what you think or what you may perceive. It has to be according to the evidence that's presented. So that's where we made our decisions based. Now, there's a lot of people out there that are critical. There's a lot of people that heard things or knew things. We didn't watch TV. We didn't watch
Yes.
the
We didn't read
news.
the
We
paper,
didn't
didn't
take
look at the internet.
all the
Yes.
outside information like everybody else knew. Our job, according to the justice system, was to take the evidence that was presented and make a decision and deliberate between the 12 of us and come to that conclusion. So, I know a lot of people are critical, but they weren't where we were.
They didn't sit in the courtroom for 6 weeks, and they didn't hear all the testimony that we heard, and didn't see all the evidence that we heard. And I know there was a lot of it, and I know a lot of the papers printed things, and
Right.
how they felt maybe it should have turned out and everything. But I still think we got it right based on what we had. And I know the district attorney's office wasn't overly happy with the Tucci decision, the Mr. Tucci decision, but we just didn't feel there was enough evidence
It has
presented
to be
us beyond a reasonable doubt.
And not to speculate.
And
Yeah.
we to the letter of the instructions by Judge Moran, we went. Like words meant something to us, and we basically went by how he instructed us to deliberate and everything.
This was my first
Yeah.
jury
Yes.
summons, so
Yeah.
I took that very seriously.
We all did. I think there was 12 of us in there that every one of us took our job responsibility or our responsibility very, very serious. And
I thought we all did pretty good with emotion, too.
Yeah.
I mean, you can't let emotion play a role in that either because you're going by facts that are present.
yeah.
How hard is it, though? I mean, it is an unusual situation in that you have a mother and sons
I'm a
accused.
mother.
Exactly, so
Yes,
accused
I
of
have
this
boys.
homicide.
Yeah.
How hard was it to kind of just sit back and take a just sort of objective look at that?
There's lots of different ways that, I would look at it personally because I'm a mother and my heart breaks for that family. And on the other hand, there's always consequences to our actions. So I had a lot of emotions that I had to keep in check. And I did. I mean, you could look at evidence, that's been my profession too. You look at facts, you look at information, and you process based on those facts.
Yeah, and I'm a mother also, and I have a daughter that's 6 years old, same age as Laura's daughter, but that did not affect me because we had a duty. We were on jury duty. We had a job to do, so we needed to do that and separate that. That's why we were chosen.
Sort of following up on that, though, how hard, because there was some testimony about, there's the plan moved to North Carolina, and there was some tension, et cetera. How hard is it to sort of step back and not wonder about everything that precipitated this, whatever caused this horrible event, and just focused on the evidence at hand?
I have something to say about that because we didn't know a lot of that. We only knew a small piece
Right.
that was in the courtroom. We didn't know about all the things from the outside that everybody else had the privilege of knowing. So we could only make the decisions based on the information that we were given in the courtroom. So we called them events because, when you say events, it kind of takes the personality, the personalness out of it. So that sort of helped me just to step back and say, okay, this is an action, this is an event, and what are the consequences to that event, and what are the facts that pertain to that. So that's kind of how I did it. What about you, Rich?
I mean, basically the same there. Of course, my youngest child is the same age as Colin, so it was kind of, and we were all asked this question by Judge Moran in the jury selection itself. So, and it just,
Right,
it didn't, I mean, obviously, for whatever reason, they felt that there was a connection with people that had children the same age as some of the defendants and everything, and but still felt we could make a fair decision and everything, which we did. I mean, like again, we all took it serious. I think we're all professional, and I remember Judge Moran asking, basically asking, have you heard about the case? And I think to a T, all of us had read about it to some degree and everything. And one of the questions that he followed up was, can you make an objective decision on the case if you were chosen as a jury?
Right.
And yeah, I mean, we felt we could separate that personal bias or whatever it may be at that point from the actual facts that we were to hear and everything. So
You have to. It's factual information.
yeah,
And, you can have your own emotions or whatever, but you can't make decisions based on emotions, speculation. Clara,
Speculation,
that was
yeah.
your word, yes.
Yes.
You can't do that. It has to be on the facts and the evidence that's presented and nothing outside it.
And,
nothing
we
outside of that.
definitely took in considering these are people's lives.
Mm-hmm.
It was not a game. This is
absolutely.
people's lives. That's in our hands, and we had to make sure we made the right decision. And like Rich said, and I believe it, and all of us, we made the right decision pertaining to what evidence that we had.
remember, we didn't volunteer for this. We were asked to
That's
do our
right.
civic duty. So
That's true. That's
you know, if people feel that we didn't make the right decision, well, so be it. I mean, there's nothing we can do about that. But we made the best decision based on the evidence and the law
Yes.
and in our instructions.
And
So,
they were not there,
Yeah.
and they were not
That's right.
through the whole case. They were not sitting there, and they weren't there to know what we actually went through.
right.
And afterwards, I mean, people were talking to me and they were saying, well, did you know this and did you know that? And I didn't know that.
Yeah, we
So
didn't.
I felt like everybody else knew more, but then again, are they facts? I mean,
Yeah.
I don't know. We're only going according to the evidence that we were given.
Yes.
So,
We went into the deliberation room, and one of the first things we said is they are all innocent until we can prove by
Absolutely.
whatever evidence that was presented to us they're guilty.
Absolutely.
And that's how we started. And I think we did what any jury did. I think we just got kind of a benchmark vote to see where we were and everything, right?
yes.
So, and that kind of set the stage for us.
We took a tally multiple times.
Oh my gosh, yes.
Multiple
Lots of
times.
tallies.
I mean, if you're comfortable answering this, how, with the different defendants, how were you with the murder charges at the start?
Well, I don't want to get into the specifics on the different charges and where we were on them, but let's put it this way, that we looked at them all individually,
Yes.
and we went and began then to weight the evidence, piece by piece almost. So
That was a big thing,
It was.
separating everything out. I mean, we had to know whose clothing was for who, and separate that out and break it apart, and then look at the blood. The comparisons, the swabs. There was a lot of information. I mean, there was a lot of detailed information. I mean, even with the map, I mean, we had to look at that and, where
The
did
cell
they
phone
go? How
pings
did
and,
they get there?
Yeah.
Yeah.
That was important to us too, to see that.
Was the spatter, to use the right term, was the spatter
Not splatter.
evidence was the spatter evidence very important to your decision making?
I think you said it perfect when
Yeah.
the trial ended. They caught you outside there, and it's the blood of Craig Rideout spoke to us and everything.
Yes,
So,
yes.
so I would leave it at that and say that
Yeah.
at this point. Yeah, it certainly was. You can kind of interpret it the way you want to. But.
Did you? I mean, it's interesting you make that point because sometimes the victim can get lost in the process.
Yes.
Were there times you thought about him?
Oh, God.
During the trial itself or during the deliberation?
Either one.
Well, first of all, we couldn't talk about the case. That was one of the hardest things to do,
Yeah.
don't you guys
Amongst each other during the trial. So when we'd go to lunch,
Yeah.
we could talk about our kids and
Yeah.
our family, and that's how we got to know each other
Yeah.
so well, because you can't talk about
Can't
that.
talk about. So I think that it was kind of hard to do. I mean, because here we're sitting with all this information, and you want to kind of talk. Okay, what did you think? We couldn't do that.
But the
So-
one thing that I do want to say in relation to that is the victim is a person, a human being.
Yes.
And the people that were on trial,
Yeah.
the defendants, they're people
They're-
and they're human
right,
beings.
they're human beings,
so
too.
you think about everybody
Yeah.
personally. You think about those people, and but you can't let that shade or darken or enlighten nothing. It has to be completely separate.
Yes, and also with Craig, they didn't talk about anything personal.
Right.
That kept getting pushed away and like objected to and stopped
Yes.
anytime. So
Yes.
we didn't know character. We didn't know anything like that. You know, like on the TV, you hear all about him, and you know, so we just knew he died and how he died.
Yeah.
Right.
It was just that plain. It was just very generic. We just know what happened to him. We didn't know about
Right.
him and his
Right.
character
The-
until
the
after.
event.
After.
After.
Yeah.
The
Until
event, as it was
after.
called all the
Yeah.
time, the
Yes,
event.
the
Yeah.
event.
But I think we thought of all of them every day.
Yes.
I mean, you could not separate that. It was just, but we always kept in mind. We had an open mind. We kept in mind that everyone was innocent until proven guilty, and yes, there was a tragedy here, a horrific tragedy and everything, and we didn't lose sight of the victim himself. So during that whole thing.
So we're talking here some 4 or 5 weeks after you gave your verdict. Sentencing is 2 days from today. I understand that some of you and some of your fellow jurors are planning to be there for the sentencing. Can you say a little bit about why you want to be there and why that's important to you?
To me, that's that's closure.
Yeah.
Closure.
yeah.
That's closure.
Yeah.
We want to see it to its conclusion. We spent so much time, together and in the courtroom, and
It'll be kind of a mini reunion, kind of.
Yes, we do.
Yes.
We do all get to see each other, and we've all become friends through this because through deliberation, that was a long time,
Yeah.
deliberation, and we all kind of got to know each other and a lot about each other because there'd be one thing one person would say, well, let's go back and look at the coroner's report, how much weight does this have and how is this in relation and to this specific person that we were deliberating about. Each person had a very important piece to bring to the table at that, so that I think will keep us pretty close, as people. So
when Claire and I were talking yesterday, she had mentioned something to me that, and I feel strongly the same way about it, that there was a reason we were all brought together for this particular trial.
Yes.
I mean, I think it's unique. I think Judge Moran complimented us for our deliberation and how focused we were and things like that, because we did. I think they used the word methodical. And I think we were very methodical in there.
Yes.
I mean,
we had to be. I mean, there was a lot of evidence.
there's so much
and
evidence and everything that
a lot of information to process. So
and like I said, we kept going back to words. Words meant things to us. That's why we wanted to we hear the rereads and everything. And I think we learned a good lesson on the first reread, though, where we needed to narrow it down a little because we just wanted a certain portion. So, and I think after an hour, poor was it Janine? The
Yeah,
court stenographer,
yeah,
God bless
Janine.
her, she was wonderful.
Yeah.
Oh, she had to read all this stuff back, but
Gosh, her voice had to
but we
be
learned a good lesson how to
very
kind of
hoarse.
narrow our search down, I
Yes.
guess, or on the rereads and everything.
you
so.
have to be specific
Yeah, you
in
gotta
what
be
you're
very
requesting.
specific.
Because if you take too much information back in your head, you're losing sort of the importance of that one piece that you really wanted to clarify.
Yes.
So we had to really get very specific so that we could stay on task. It was a learning experience
It
for
was.
me.
It was.
So what if, this is something you'll never forget, I'm sure. But years from now, any thoughts of like what the takeaway will be when you think back on this? Any lessons, any memories, anything in particular that's just going to stick with you about this?
For me, I just kind of look at it as a sad event. It's just, it's a terrible,
sad,
it's a
yeah.
terrible thing that happened,
And accountability. I
yeah.
mean, we have to remember in our society too that there has to be an amount of accountability for the actions that we do. And we have to, for me, I've tried to teach my kids that too. If you make a decision, you have to be able to accept that accountability that's going to be coming your way. So
Yeah.
that's
and
that's my thing.
also, we did our part as being Americans. We completed
Yeah.
what we were supposed to do, and that's where I felt accomplished. Like this was a sad event that happened, but we were chosen, and we did our duty. As an American, we have a right to do that.
I mean, we saw the judicial system. To me, it worked.
Yes.
I mean, I really was impressed with how it's streamlined and everything through. And it wasn't Perry Mason, it wasn't Ben Matlock or NCIS or anything like that, but. And at times, yeah, I know. I think people think it's like that sometimes.
In the movies or on TV.
Yeah, I mean, no one got
It's
up and
not how it is.
screamed, I did it or anything like that. So the burden was on us then to prove either guilt or innocent. And I still say we got it right based on what was presented to us. I don't have any reservations.
Based on what was presented
Yeah.
to us, I believe that.
Yes.
I really believe that.
And as far as what Rich said about the judicial system, I have a whole different view on the judicial system. When you hear people got off or or got sentenced, or I'm not saying the right word, convicted, that and people just get upset about it. Like they probably got upset about this case. Some people, like I was there. I seen how the whole process went, and I respect the process. And we all have to respect the process, regardless if you don't like it or not.
It was disturbing for me. It was
For those of you a little history lesson that know your Enlightenment time period, Voltaire said, "I'd rather see 100 guilty people go free than convict one innocent person."
That was brought up.
Yes,
Yes,
I know.
Yes,
So-
I did learn that from
Yes.
you.
Yes.
Did you use that during deliberation?
I won't say whether I did or not, but so.
Well, Rich Bott, Mary McKeon, Clara Washington, thank you very much for joining us. 3 of the jurors at the Craig
Thank
Rideout murder trial, and Gary Craig, my colleague. For more of our coverage of this case, visit democratandchronicle.com. Thank you.